Hello, everyone. Welcome to UPC Insights, the podcast for European patent professionals. I'm George Walden, your host, and today's episode focuses on the evolving relationship between UPC and EPO case law and whether the UPC is aligning with or diverging from established EPO norms. Our guest today, in my opinion, is a UPC legend as well as a trusted expert and advisor in the UPC movement. He is a UPC representative and patent litigator, Tilman Pfrang, who has studied recent decisions, including inventiveness and added matter from different UPC divisions. Tilman, as always, great to have you with us.
Yeah, thank you, George. I'm so happy that you are back, actually, after your injury with your knee.
Yeah,
Some
Brazilian
episodes
jiu-jitsu.
we had to record with audio. It was difficult. I'm very happy that you're back.
I appreciate it. I appreciate it. I'm glad to be back. So, Tilman, let's get started because we've got some really interesting things going on. So, are you ready?
I'm totally ready, yes.
There you go. Tilman, why is this comparison between the UPC and the EPO case law particularly important at this stage of the game?
Yeah, I would say we are now over 2 years into UPC operation, so actually 2 years and 2 months. And
Precise. Ooh.
yeah, as always. And looking back, I mean, no one actually knew how the new two big players, or one old big player and the new big player for European patent law, would decide about certain issues and how they would consider or not consider the decisions of the other one. And now, actually, I can say that already, in particular regarding validity, of course, because the EPO deals with validity only, that there is interesting amount of case law where we see that both authorities converge towards each other. There are still some issues where they are further remote, but in many regards, they converge, actually.
So then how closely is the UPC currently aligning with the EPO practice on inventive step? That's curious to me.
Yeah, and that it's a good question, and it's good that we focus at this moment on inventive step because the EPO is famous worldwide for their problem solution approach. This is an EPO invention, this is EPO practice, and as European Patent Office, it was of course the big question, will the UPC or will the UPC not adopt this approach, or maybe also present a variation of this approach, or will they develop a totally different approach? So the answer is it's not decided yet. However, if you look at earlier decisions, there it was rather clear that the UPC, or it seemed rather clear that the UPC is not so keen on simply adopting the problem solution approach. There were decisions from the Paris local division and Düsseldorf local division, also Munich local division, other divisions, where they used their own idea of how to assess inventive step, starting from a very early case of the central division in Munich, where they also adopted their own approach. Sometimes it was, for example, the Paris local division, they just mentioned the problem solution approach. And in one case, the Paris local division said, well, we did not use the problem solution approach. If we would have used it, the result would have been the same. They did not even say why. It was not so popular among the divisions. Then rather recently, actually, as far as I know, the first division where it was not put into doubt that the problem solution approach can be used and could be used in that case was a rather famous decision of the Hague division. Famous because it was the first decision where they actually elaborated in detail how equivalent patent infringement has to be assessed. But also in that decision, they said, well, the parties used the problem solution approach. We don't see any reason why we shouldn't. So they used the problem solution approach as the EPO proposes it, and did not provide any alternative or so. And not very surprisingly, by the way, because the Netherlands have their own tradition regarding the problem solution approach. This is definitively a national jurisdiction where the problem solution approach is common. And very recently then, very interestingly, the Munich local division, so a German local division, also carefully applied the traditional EPO problem solution approach in their inventive step analysis. And they even said, well, we do this with a purpose. We believe harmonization is the goal of the UPC. And there is this body of case law of the EPO, and they use the problem solution approach. So they even said this division, so they were talking about themselves, this Munich local, or this panel, actually, they said, this panel, so the Munich local division, or one of the two panels of the Munich local division, shall use the problem solution approach because we believe it's beneficial for harmonization and so on. So I think this is a strong word in a legal context. Shall use. My understanding is you can expect at this panel of the Munich local division that in future cases they will use the problem solution approach. We have to see whether this is true, but for me it very much sounds as if this would be the case. So a clear handshake with the EPO at the moment.
So closely mirroring the EPO approach. Yeah. So with the problem solution, before I get to the next question, is that something that people use, like The Hague and Munich or wherever, they use it in their own way? They stick to it, but they don't necessarily have to stick to it. Is that what you're saying, or?
Yeah. This depends much on the panel. And of course, also the Munich local division would not say, well, you cannot use any other analysis or approach. Mm-hmm. And by the way, even the EPO, rarely, but sometimes, some boards of appeal say, very rarely, but sometimes, that this is not the only possibility to assess inventive step. And it has its downsides. I mean, also it becomes, for example, difficult if, I do not want to go too much to detail, but it has some difficulties when it comes to an invention where even the parties would agree that there is no particular advantage or so. Then it becomes difficult. Then the objective technical problem is like finding an alternative, and it becomes a bit messy then.
Yeah. Okay. We can go for that one our next show. So this brings us to the next question then. Are there emerging differences in how the UPC versus the EPO handle the closest prior art or problem formulation?
Yeah, starting with the terminology closest prior art, this is a term used by the EPO. Mm-hmm. The idea is, in theory at least, that there is the one most promising starting point or springboard, which is the closest prior art, the prior art which is closest to the invention. Mm-hmm. And theoretically, it is only possible for a correct problem solution approach to start from this unique closest prior art. If you start from another one, you are not working according to the problem solution approach. This is something which makes troubles in the practice before the EPO, because often it is used also as a pressure means of the patentee, actually in an opposition case, and sometimes maybe even of the divisions, that they say, well, you cannot start from 5 different prior art sources because there is the idea of the one closest prior art. So tell us what's the closest prior art, and from that we can go on. At the UPC, this was never the case. Even the divisions, the Hague division, Munich division, which used the problem solution approach, did not adopt this aspect or even the idea of the closest prior art. They use sometimes the term, but mostly they say we need a realistic starting point, and from that we can go on. And a realistic starting point can be one of 5 or 6 or 10 realistic starting points. Mm-hmm. So it's easily possible before the UPC to bring your arguments starting from document 1, document 2, document 5, and so on, which is often troublesome at the EPO. However, again, our episode today is about convergence and divergence and so on. However, again, I believe to see a similar development at the EPO in another direction. There was always case law saying that, well, there may be different starting points. Also, the term realistic starting point has been used by the EPO in the past by the boards of appeal. But nonetheless, I think now more often they see this more relaxed, and also there's one decision where they were very clear in that, well, we understand you can always assess an invention from different angles, and you can also analyze the prior art from different angles. So we believe there may be several close prior arts. So they did not even use the term closest, but close prior arts. And they also admitted that it's well possible to start from any of those close prior arts, as long as they, and interestingly, they use the same term as the UPC, as long as the respective prior art is a realistic starting point. So there's the term again, realistic starting point.
Yeah.
In the present case, they said, by the way, the starting point of the opponent was not a realistic one. But it was not the question whether it was the closest one. They just said it's not even a close one.
Okay.
Yeah.
Well, I mean, so it's starting to look like a trend. Do you notice a trend with how this is starting out, or is it something that's still not exactly, you can say it's going to be this way or that way, but it just seems like a light trend is starting to develop with that?
I would say so. I see, maybe you can even say they are on the way to find a harmonized approach, a harmonized meaning that the UPC and the EPO use the same ideas in the end.
Okay, interesting. What about the skilled person standard? Do we see any nuances compared to EPO or national courts?
Actually, there I see more similarities than differences. What was always popular at the EPO was to define a skilled person, for example, as a team. If you have an invention which relates to maybe some IT aspects and then some engineering aspects, then they would say, well, it's an IT person and an engineer which work together in a team in order to solve the so-called objective technical problem. Also at the UPC, you see this in some decisions, this idea of a team, by the way, also on the national level. In Germany, it's not so common. Normally, there's the one person which has to solve, or it's supposed to solve the problem. But I have to say there I see more similarities.
Okay. Yeah. All right. Then let's turn to added matter. How has the UPC case law addressed intermediate generalization so far? Now that's got to be something different, huh?
Yeah, another term I believe the EPO has invented, the term intermediate generalization. So what does it mean? Let's assume you have a disclosure of fastening means, and you have also disclosure of a metallic screw, but nothing else. Then an intermediate generalization would be something in between. So not a metallic fastening screw, but a screw in general. So something more specific than the most abstract feature, namely the fastening means, and something more abstract than the specific metallic screw. This is an intermediate generalization. So you omit, in other words, a feature among a combination which has been disclosed. And here it's interesting to see that some local divisions use again the term gold standard, also invented by the EPO. What they mean with this is just the gold standard is a code word for a direct and unambiguous disclosure.
Okay.
And now it becomes interesting. So the EPO always asks for the direct and unambiguous disclosure, as the German Federal Court of Justice does, and now also the UPC does. But everyone seems to mean a different thing when they're talking about a direct and unambiguous disclosure. So in other words, for example, the German Federal Court of Justice would, at least in my opinion, and I think many would share this, be more relaxed on the question of origin disclosure, specifically intermediate generalizations. Now we have the UPC, and in some decisions, I have the feeling that they are very close to EPO standard. So EPO standard is strict. So in the example above, I think it would be very difficult before the EPO to get a subject matter allowed which is relating to a screw in general. And probably they would say, well, you must write down metallic screw. And the UPC in some decisions is as strict. However, in a recent decision, Paris local division also was clearly more relaxed. And also I had the clear feeling that they wanted to make a point. They said, generally an agreement, intermediate generalizations should be scrutinized very carefully. But we also would like to involve some common sense. They did not say that, but this was my reading. We would like to involve some common sense. They said, well, it is clear for the reader that if you disclose a certain feature, and in this context, you also make a description of other features, it's clear for the skilled reader that obviously the author of that text didn't want to say you can only incorporate everything of this. The skilled reader would acknowledge some things are just there for making the embodiment working or whatsoever, just as in maybe a kind of a further clarification of the specific technological solution or so, but that not all features which have been written down are absolutely necessary for the one feature you choose.
So how can you justify where you're going to fight your case and then what you're going to do with it? You know?
In this direction, it's difficult. The case I was talking about, by the way, was the Paris local division in Hurom versus NUC, and there the head note I have now found it is they said, however, and they are talking about the arguments of the defendant. However, the argument from the defendant that no less than 8 features are inextricably linked is unfounded, as the defendant has not demonstrated the link, and the skilled person would understand.
Yeah.
And this was my point. Would understand that in describing an embodiment, features may be used to illustrate its working that are not necessarily an essential part of the invention. Consequently, the amended claims do not comprise added matter. And this is where I said, well, my reading is please some common sense, and the skilled person understands or is well capable of reading a patent application properly. And I think, what was your other question, George?
It was just a matter of where would you like to try it? How do you know the place?
Yeah, the problem is usually you have not so many alternatives. If you find an isolated revocation action, it will be always the central division, and depending on the technical subject matter, either Paris, Munich, or Milan.
Okay.
And in case of a counterclaim, you normally stay with the forum or the division the infringement claimant has chosen.
Okay.
So there you have to raise your counterclaim for revocation. So there's no forum shopping there.
Very well put. So how should practitioners use this developing UPC EPO interplay strategically?
I would recommend for any practitioner that it's totally fine if they use their experience on EPO practice, that they even cite all Board of Appeal decisions, or even better, decisions of the enlarged Board of Appeal. But they should be very aware that there are at least subtle differences between the two bodies of case law, and that in a specific case, in a difficult case, they should always try to counter check whether any idea or methodology or approach which is standard practice at the EPO identically or at least similarly works at the UPC. And be aware that not every division has the same idea of, for example, analyzing inventive step. So at least one of the panels at the local division in Munich, we have talked about this. It would be probably a good idea to use the problem solution approach. I'm not so sure whether, for example, at the local division in Paris or in Düsseldorf or so on. Yeah.
So a gold standard for the EPO is obviously the gold standard for the EPO is different than the gold standard, if I can say it, from the UPC.
Yeah, they have their own. They would probably call it platinum standard, but
okay. The arrogance is real. My goodness. Okay. Well, okay. Looking ahead.
No, it's not like that.
I know what you mean.
It was just a joke, but I think the relationship is actually much better than many have expected. So there's a lot of trust among the authorities, EPO and UPC. Yeah.
Then looking ahead, do you think the UPC will eventually develop its own distinctive doctrine, especially on an inventive step and added matter, or their own platinum standard or gold standard, if you would say?
Yeah, that's definitely possible. Maybe together with the EPO, actually. And we have seen first signs. At least I believe that there are first signs that the EPO or the boards of appeal of the EPO are moving also towards the UPC. Maybe together they are developing a new standard, or the UPC on their own. In the end, they will always be interplay with the EPO in the end. I assume that we will learn a lot also from the Court of Appeal of the UPC. Because for these questions, inventive step, added matter, so the most prominent items maybe on the list of relevant topics, there were decisions but not decisions with head notes telling us a lot how to analyze it. And most of the decisions of the Court of Appeal, we must not forget, that are still about preliminary injunction proceedings. So where there's always a hurry and things must move fast, and maybe where the Court of Appeal is not so confident that this is the right decision to put out something very general. But I think that sooner or later we'll see some head note decisions where we obtain more guidance on how to deal with these issues, and then it will be the question whether they may maybe strictly or flexibly adopt the problem solution approach and so on. So far, only the first instance has adopted the problem solution parts, and only some of the local divisions.
Have you heard of any or witnessed any decisions that have left you scratching your head going, what was that? I mean, just out of curiosity,
on daily basis, I would say no. No, actually, you see that the decisions of the UPC are well founded. They put some effort in establishing a good basis for the future of the UPC.
And that brings us to the end of this exploration of the UPC and EPO case law convergence. Tilman, thank you so much for these insightful comparisons once again. And it's clear that while the UPC is aligning closely with established EPO practices, especially on inventive step and added matter, practitioners must stay alert to emergency nuances. I guess that's correct, isn't it, Tilman?
Absolutely, yes.
To our listeners, if you found this discussion helpful, subscribe to UPC Insights and share it with your peers. Stay tuned for future episodes where we'll delve deeper into specific UPC decisions and litigation strategy. Until next time, I'm George Walden, and you've been listening to UPC Insights. Thanks for joining us.